Hello. On October 31st, 2019, USDA formally issued an interim final rule establishing the USDA Domestic Hemp Production Program. The following is a basic overview of the program. To begin, we will provide a basic overview of hemp-related provisions under the 2014 Farm Bill. Under the 2014 Farm Bill, state departments of agriculture and institutions of higher education were permitted to produce hemp as part of a pilot program for research purposes. The 2014 Farm Bill did not allow for the production of hemp for general commercial activity. It also did not remove industrial hemp from the controlled substances list. Moving forward, the 2018 Farm Bill removed industrial hemp from the Schedule I list under the Controlled Substances Act. It also directed USDA to develop a domestic production program to review and to approve plans submitted by states and by Indian tribes. It also directed USDA to establish a federal plan for those producers in states and tribes that do not have a USDA-approved plan, as long as the production of hemp is not prohibited in those states or tribes. It extended the 2014 Farm Bill provisions for 12 months after the 2018 Farm Bill provisions come into effect. Please keep in mind that states and Indian tribes may not prohibit the interstate transportation or shipment of hemp that is lawfully produced under a state or tribal plan or under a license issued under the USDA plan or the 2014 Farm Bill. The following are some basic provisions of the interim final rule. The interim final rule is effective upon publication in the Federal Register. Publication occurred on October 31st, 2019. The interim final rule includes a public comment period allowing USDA to seek input on the rule as it is enacted. USDA will use the 2020 growing season as a chance to test drive the interim rule to help guide any adjustments that are made in the final rule. The interim final rule sunsets after 2 years, which allows time both to make it through a full crop cycle and for USDA to deliver a final rule. The following slide summarizes some issues around tribal jurisdiction. The rule notes explicitly that a tribal government desiring to have primary regulatory authority over the production of hemp in the territory for which it has jurisdiction can administer a USDA-approved plan for hemp production. This is true even in cases in which tribal lands may be contained within the boundaries of a state which has explicitly banned the production of hemp, or a state that has a USDA-approved plan, but for which the tribe has land jurisdiction. With the publication of the interim final rule, states and tribes may not prohibit the interstate transportation or shipment of hemp that is lawfully produced under an approved state or tribal plan, a USDA-issued license, or the 2014 Farm Bill. The following slides summarize other key provisions of the interim final rule. The interim final rule provides guidance on some of the basic provisions needed from states or tribes to obtain plan approvals. State and tribal plans must include the following. They must include procedures for tracking the land where hemp is grown, procedures for testing using post-decarboxylation or other similarly reliable methods for delta-9 tetrahydrocannabinol concentration levels, otherwise known as THC. They must include procedures for disposing of non-compliant or hot plants. They must include compliance provisions, otherwise how to handle violations and requirements for inspection of farms. They must include procedures to share information, and they must be able to certify that the state or tribe has available resources to manage their plans. The interim final rule provides for a 30-day waiting period for USDA to license producers whose states or tribes do not submit plans for approval. Producers in states or tribes that will have a plan are expected to enroll in those plans. The interim final rule also contains requirements for sampling of hemp. States and tribes must ensure that a representative sample of the hemp production is physically collected. Sampling must be conducted within 15 days prior to the anticipated harvest. A USDA-approved sampling agent or a federal, state, or law enforcement agent collects samples from the flower material of the hemp plant. A guidance document, which was issued outside of this interim final rule, includes the specific steps for sampling, including how to collect a statistically representative sample. This document is available on the AMS website. Please note that alternative sampling and testing protocols will be considered if they are comparable and similarly reliable. Testing requirements are as follows. Testing must be completed by a DEA registered laboratory. Any licensee may request that the laboratory retest samples if it is believed the original THC level test results were in error. A measurement of uncertainty, or MU, must be estimated and reported with test results to ensure the test uncertainty is taken into account. If the actual THC level is within the range of MU, the results will be considered to be acceptable. A measurement of uncertainty is a scientific calculation that makes allowances for variation in sampling and testing procedures. If a test result is up to 0.5% THC concentration, the result is not considered a negligent violation. However, the crop still must be destroyed. The Farm Bill specifies that producers with more than 3 negligent violations in a 5-year period will be ineligible to participate in the hemp program. The following slide is a summary of some basic provisions for hemp producers. To produce hemp, you first need to be licensed or authorized under a state, tribal, or USDA hemp program. The program plan you are licensed under ultimately depends on the location of your hemp growing facility. The first step is to contact your local state Department of Agriculture or tribal government to see if they have a hemp production plan that has been submitted to or approved by the USDA. If your state or tribal government has an approved plan or is in the process of developing a plan, you must apply to and be licensed or authorized under its hemp program. If your state or tribal government does not have a pending or approved hemp production plan, you may apply for a USDA hemp production license. Applications to obtain a license to produce hemp under the USDA production plan are available on the USDA hemp program webpage. Please remember that you cannot receive a hemp production license under a state, tribal government, or under the USDA plan if you have been convicted of a felony related to a controlled substance sometime in the last 10 years. Basic steps to becoming a hemp producer under a state or tribal government plan are as follows. Step 1. Apply to the state or tribal government and receive authorization to grow hemp. Step 2. After you have planted hemp, visit your local USDA Farm Service Agency office. Provide the FSA office with your state or tribal license or authorization identifier. You should also provide the FSA office with the geospatial locations where you are growing hemp. Upon doing so, you will receive a lot number or lot numbers from the FSA. Please remember, when it is time to sample the lot for THC content, you will request an authorized agent come to sample each lot. You will also be required to follow proper sampling and testing procedures for measuring hemp THC content. Also, you will be required to submit all required information to your state or tribal government. Under the USDA plan, The first step is to verify that your state or tribal government does not prohibit the production of hemp. Next, check to be sure that your state or tribal government does not administer a hemp production program. The following step is to submit to the USDA hemp program an application and a copy of your FBI criminal history investigation report. A link with instructions on how to obtain the FBI criminal history report is also available on the USDA AMS website. After you have planted hemp, you must visit your local USDA Farm Service Agency office, provide them with your USDA license number, and also provide the geospatial locations where you are growing hemp. Upon doing so, you will receive a lot number or lot numbers from the FSA. And finally, you must remember to always submit any required information to USDA that is required under the USDA hemp program. Over the next several months, the next steps for USDA are as follows. AMS plans to work with states and tribes to approve their draft state and tribal plans. And also, beginning 30 days following the effective date of the rule, USDA will begin to review license applications from those individual producers in states and tribes that do not have a hemp production plan. Please keep in mind, for more information, you can always visit the USDA Hemp Production Program website at the following link. Additionally, you can always submit questions to us at farmbill.hemp@usda.gov. We appreciate you listening. Thank you.